Just 4 minutes on this, please.
Yes. You see, Roland, you see, when you have two children,
is it quite in timing? When it's time to tell me.
When you have two children, the way you respond to their concerns give an indication whether as a parent you are really parenting well or not. The reason why I make this point is that the NPP currently have this feeling and they are emboldened to demonstrate a lot of impunity in this country because they believe
How so?
that there are no consequences for their action. That is the current mindset of the NPP. You see, the only reason why we are here is that the NPP is running away from the precedent they set in the year 2020. That is the only reason why we are here. When Okwe gave that ruling against Esiama, listen carefully, it didn't bother them because at that time they had a lot of, they had a comfortable majority. And so whether Esiama was available or not could not stop them from conducting business. But you see, anytime you take an action that is short-sighted, an action that is not informed by other implications, you get to this point.
How was that short-sighted?
Okwe ruling was so short-sighted that he didn't also look at the reverse. A situation where you have only one majority and you are losing one, what will you do? You see, this morning, my friend here makes the point that, and you see, he states the law in ex parte lie and applies it wrongly. Ex parte lie only deals with a situation where judicial processes or whatever that requires a hearing, you have not been heard. That is what ex parte lie says. The fundamental question in applying ex parte lie is to ask yourself, who is in court? Is any of the affected MPs in court? So at best, per your reasoning, Afenyo Makin is at best a busybody. Is he one of the affected MPs? Has his seat been declared vacant? That requires him to go to court to allege a breach of natural justice. What law are we propounding? Where you have not been affected directly by a decision, you go to court and say, I'm complaining about somebody else.
What if he's going as a head of the majority caucus?
Please, was a decision taken about the majority caucus? Individual seats have been declared vacant. The 4 MPs, none of them is in court. That's an afterthought. They have lost all defenses. So basically what they are doing now is to be running octopus all over the place, trying to find a reason to hold on to. None of the affected MPs is in court.
The Speaker, what should be his position tomorrow?
I will deal with that. You see, I have always maintained, yes, the only reason why Russia or the United States of America has never attacked Russia, do you know why? Because there's something called mutually assured destruction. Listen carefully. Mutually assured destruction. The US of A knows that if they fire a missile into Russia today, Alaska is just a distance away. You see, where people decide to disrespect you in a co-equal manner, what you do is to assert your authority. If you remember the famous US case, the Still Seizure case, Justice Frankfurter has something. He said the concept of separation of powers is to demonstrate separateness, but interdependence. You need a situation where these co-equal arms of government must respect each other. The manner in which the court intervened, the speed with which the court intervened is becoming one too many. And I'm worried. Look at the manner in which Parliament passed a bill. And then somebody goes to court and says, we are injuncting the transmission of the bill so passed to the president for assent. And today the matter is in abeyance. When you do that, what you are doing is that you are using the Constitution as it were to project a particular mischief. And that is extremely dangerous. I'll conclude on this. Oh, no, let me just 30 seconds on this.
Because how many more minutes?
If you read,
he's past 2 minutes.
If you read Article 99, Article 99 says the High Court shall have jurisdiction to hear and determine any question whether, listen carefully, the seat of a member of parliament has become vacant. What the Supreme Court, it's a question whether the Speaker can declare those seats vacant or not. How is that a matter for the Supreme Court?
What should be his posture tomorrow? I asked you that question.
And that is why I said, I gave you the example of US. When people know that their actions have consequences on others, they will sit up. And so I strongly believe that the Speaker is the head of a co-equal arm of government called the legislature. He must accept the dignity and authority of Parliament tomorrow.
Now that could lead to a constitutional crisis. 4 minutes for you.
Yeah, first of all, you should not present it and make it look as though the NPP only went to court to file for an application for stay of execution. There is a substantive suit that is sitting, at the Supreme Court.
Very well.
Yes,
very
and
well. That's public knowledge.
Yes, and that substantive suit has to do with whether or not the declaration made by the Speaker, he had the powers to do so. So there's an interpretative question. So Article 99 doesn't come here in the first place. Let me land. No, you can. If I'm wrong, you can. Let me land when I finish with my submission. Article 99 doesn't come here. Don't defer it to the High Court, because there is a question of interpretation here where the Supreme Court has to make a declaration. Again, I think reference was made to the standing orders where you read it on television for everybody to see. It is instructive to know that even in the standing orders, at no point did the standing orders require the Speaker to make a declaration of seats.
Read what the Speaker said. No.
Should I get up and go? What is this?
No, please let him have his. No. Eduji.
Correct. No, I will not allow you. Stop that. Where do you come from? When you are talking, you think we are not misinforming people. When we are quoting Article 99, when we are quoting Article 99, misapplying it wrongly, you think we are not misinforming people.
What did the Speaker do?
What? Oh, Eduji. We're senior.
No, please. We'll play the video of the Speaker. Please get a video of the Speaker.
I will even move beyond that argument.
No, your 3 minutes is a short. Please go on.
I'm saying that even if you read order 18 of the standing orders of Parliament, it requires the Speaker to inform, not to make a declaration. If you look at what the Speaker did, of course, he argues that he was applying the constitutional provision. But you see, at no point can you apply a constitutional provision without, first of all, placing a meaning onto it. Because you have to place a meaning and understand within a certain context or perspective before you'll be able to apply. And that's applied to interpretation.
At what point do you determine, or how do you determine if Speaker, whether it's Michael Quay or the current Speaker, Bagbin, made a declaration of informing Parliament of a vacant seat or not, or rather made an interpretation and so said the seat was vacant?
I am saying that whichever way, it is not the decision of the Speaker to make. It's the sole reserve of the Supreme Court, and that's why we filed a suit in court. So when you present it as though we're only in court for a certain stay of execution, and that in this case, Article 99 should be applicable, so that the case the proper forum or the jurisdiction has to be the High Court. It does not apply within this context. Again, you spoke about the standing orders. I get the attempt to make it look like the standing orders are a bit even supreme than the Supreme Court. Now listen to...
Nobody has said that here.
Yes, because at the end of the day, the standing orders is even subsumed by the 1992 Constitution.
I think we all know.
And look at this.
But see, nobody has said that here.
Well, I'm making a point, if I'd allow me to learn. If you listen to Justice Kolindi in the Justice Abdullah and AG case and the Francis Osebo's and AG case, this is Justice Kolindi. Even though Parliament is a master of its own procedure, it cannot be overemphasized that all houses, rules, orders, procedures, and practices also have a master, which is the 1992 Constitution. So the Speaker cannot hide under the umbrella that, well, I was applying the standing orders, and within the standing orders, I have the power to make a declaration, even though the standing orders even say you can inform, and then hide under the umbrella and do an interpretative work, whilst the main work of the Speaker has to do with procedural and administrative. Again, I just want to quickly, and then react to what my senior colleague said. He was more on the stay of execution and made a submission that the Supreme Court, because there has not been precedent of stay of execution, they don't have the powers to do so. The Supreme Court actually has inherent power to grant any order. The stay of execution should be construed as having the same effect as an injunction. And of course, in ex parte application, at every point when you grant an ex parte application, it may be granted, particularly due to the extreme situation or the extreme emergency that is attached to an ex parte application. I mean, reference is made to Order 25 of CI 47. Of course, I get a bit when he said that, when in stay of execution, you cannot grant more than 10 days. I think the reference is made to Order 25 of CI 47, except to say that there is a case law in the Rosemary Kwando case. The court held that in appropriate circumstances, a court of law can grant a relief not even sought for by a party. So yes, 10 days based on the CI 47, but there's also a case law which says that the court can even go beyond that, and that is also within the remit of the law. Of course, as to whether the Supreme Court, well, okay, it's fair. Let's proceed.